Starting. All attendees are in listen-only mode.
Hello and welcome to the Micklin Law Group's monthly webinar series. Today's webinar is called Custody Solutions for Men, How to Continue Playing the Role You Want in Your Children's Lives. Now, before I go through everything that we're going to have to discuss tonight, I just want to quickly say that while it's called Custody Solutions for Men, obviously some of these issues will relate to women, but the Micklin Law Group is largely concentrated in men's and fathers' rights in divorce, custody, and family law issues. So our presentation is going to be geared in that direction. So let me give you a little background first on what to expect from us tonight. The basic intention of this webinar series is to provide some resources for both my clients and those that are not my clients, to have resources available to learn the areas of law without having to ask a million questions. I've often found in my conversations and consultations with clients that I could spend weeks talking to them on a certain topic and not be able to give them enough information. So I create these to help people in cases that may not have access to the information, may not want to be paying a lawyer for the information, just overall an attempt just to help people. So what can you expect from tonight's webinar? And all the webinars actually are usually uniform. It's scheduled for 60 minutes. I will take as much time as necessary to get you the information I think is important. Sometimes it's less, sometimes it's more, but I do my best to stay within the 60-minute range. I will take questions, but at the end. I don't like to interrupt the flow. So you should have on the right side of your screen a control panel. And towards the bottom is a pull-down menu. If you tab on there, it's called questions. And type in there what your question is, and I'll get to it at the end. Now, I usually recommend you type the question as it comes up to you, not wait until the end, so that way you don't forget it or miss it, and we can make sure to get to it for you. I did upload the PowerPoint presentation, so you should see on your control panel the handout section if you wanted to print this out. This webinar doesn't have so much of it, but a lot of my webinars will have case citations and general phrases that might be of help. This will have some, and if you're interested, you'll have the handout to print. This will also be posted within a week or so on both our website at micklinlawgroup.com and my YouTube page, which is Brad Micklin. And real quick, for the purposes of tonight's webinar, I'm going to be using traditional terms like men and women, mother and father, husband and wife. The information that I'm talking about obviously relates to same-sex couples, to in vitro families, situations, blended and extended families, and everybody else. But I don't want to spend my time fighting for the politically correct word. I'd rather get the information to you without concern. So I don't mean to offend anybody. I'm certainly not leaving anybody out. I just want to make it simple so that we can slide right through the information that we need to get to you today. That being said, let me give you a little background about me. This is me. Those who haven't worked with me, I'll give you some of my background. I am a member of the New Jersey State Bar Association. I am licensed to appear in both New Jersey state and federal courts. I began my legal career in '95 as a law clerk to Judge Eugene Austin. He was the supervising judge of special civil litigation at the time. I went from there to Kessler and Associates, where I practiced complex commercial litigation for a number of years. I liked the litigation a great deal, but I found I didn't care much for commercial litigation, corporate work. I liked dealing with people. So I opened my office in 2001, quickly concentrated into divorce, family, and custody issues. And over the last few years have been progressing into a further concentration of men's and fathers' rights in divorce, custody, and family law issues. Here are a number of awards or achievements I've been fortunate enough to receive. It's a little outdated. I've actually received many from this point forward that aren't listed here. And I say fortunate because it's nice to know that the clients I have appreciate the work I do. I put this up not to impress you, but to impress upon you that I do have a good sense of what I'm doing, and I have a good background. So you can trust in the information I'm trying to give you tonight, which is going to hopefully be a little bit of between across the legal aspect and the practical, so that you have a sense of what to expect when you do walk into court, if you do at some point in your future. First, before we get into the information, I do want to let you know about a divorce and custody support group that I sponsor and I lead. I generally do it on the last Wednesday of every month. Sometimes there's a little confusion because I also do my webinars, these webinars, on the last Thursday of every month. So they're usually back to back, but sometimes, like this month, for instance, there's a last Wednesday, but not a last Thursday that coincide, and it messed up my schedule a little bit this time. So best bet is to just go to my website, micklinlawgroup.com, and the dates each month for the custody and support group will be posted there. It's an in-person meeting at my office. We hold it from 7 to 8 o'clock. It's in my Nutley office at Washington Avenue, Suite 2F. Like I said, it is in person. It's confidential. Obviously, if you're a client of mine, it's certainly open to you. If you're the other party to a case, you cannot come. Obviously, it's a conflict. There's no charge for this meeting. It's really just for people to get together, speak their mind, share thoughts and concerns. Some just come to hear from other people so that they know they're not the only ones going through this. So everybody gets a different thing out of it, but I generally find it to be a really good experience, helpful to everybody. And like I said, I'm there, so there is a chance for some free advice, even for clients of mine. So let's talk briefly about what we're going to cover tonight. Just go over the general topic so you know what's in store. First, we're going to talk about the custody statute, NJSA 9:2-4. We're going to speak about the custody statute first, just in some basic terms, some underlying concepts and theories, and then we're going to go into the custody factors under that statute, the specific criteria the courts are supposed to look at when deciding custody. Then we're going to spend a good amount of time on the different types of custody. So we're going to talk a lot about legal and physical custody, sole versus shared custody, and parent of primary residence and parent of alternate residence, the designations and alternatives. We're going to start to conclude on some things you need to keep in mind. It may be a little bit of a reiteration of the things that we covered, but sort of closing points that are really important to store with you. And then lastly, we're going to talk about relocation and some recent developments in these areas, as obviously those involved in custody issues understand the significance and difficulty around relocation applications. So I'm going to tell you what the status of the law is there and some ways to better protect yourself moving forward in these issues. So moving right along, let's talk about some of the concepts and theories behind the custody statute. Again, that's NJSA 9:2-4. First one is probably the most important, and it's the best interest standard. You're going to hear this term a lot. It gets thrown around a lot. Because of that, I don't think it really gets considered carefully and properly by most people. When considering the best interest of a child, it really has to relate to that child, not the parents. Now, that might seem obvious, and it might not seem to say anything different, but it's more often a parent making a claim for custody or relocation specifically, and all the reasons and benefits really inure to the parent, not the child. Like relocation, and we'll talk about this at greater length, is often based on having family support or having more income. These are not necessarily the child's best interest. They're the parents' best interest. And I don't think, and that's why I'm stressing this now, that most people, lawyers, judges, and clients alike, really sit and think about that before making a best interest argument. Next is one everybody know there is a presumption, and it's a growing presumption in the law, that favors frequent and continuing contact with both parents. This obviously goes to the issue of parenting time. And in favor of frequent continuing contact really is more of a shared equal contact for both parents. This presumption is really moving into a recognition that both parents have equal rights to parent. The presumption says both parents are equally capable and competent of parenting a child. And more importantly, a child is benefited, a child's best interest, going back to the best interest standard, is served by having both parents involved as much as possible. So when you hear a parent arguing that there shouldn't be a lot of parenting, and again, I'll say like if a mother's arguing dad should have as much parenting time, that's obviously contrary to the child's best interest. And when we go through the custody factors, it's going to be things like this the court should be looking at, and you as a litigant need to be able to point out. When it comes to a custody issue, court rules require that all cases about custody and parenting time first go to mediation unless there's a temporary or final restraining order issued. Now, the court rules technically say when there's a genuine issue to custody or parenting time. But in my practice, I've found that judges find all matters of custody to be genuine. So, and I say that because there's sometimes people will file bogus application to modify, support, or change a parenting time schedule when there's really no basis for it. But they will still send you to mediation. So it's something you need to be prepared for. It doesn't mean that you have to settle. It just means you have to participate. So now, with regard to these issues, let's look at some of the things that a judge will use or employ in order to help make a decision about custody and parenting time. First thing that's often asked for and quite common, at least in requests and discussions, is child interviews, usually in camera, which means away from everybody, in private with just the judge and the child. Usually parents and attorneys are not permitted to be in the interview, but they usually are recorded. You can often submit questions that you want the judge to ask at this in-camera interview. Does not mean he or she will actually ask the child the questions that you present, but you do have that right to present them. In my experience, in-camera interviews aren't very common, although they're commonly requested, and I think they would often be helpful. But a lot of judges are of the mindset that they have no greater ability to judge a child's psychological needs than anybody else, so they turn more to experts. So most of them, in my experience, shy away from holding in-camera interviews, at least with young children, say under the early teens. Additionally, they don't like to put children in the middle of litigation. It puts the children in between their parents, no matter how gentle the court wants to be. You can't avoid that obvious issue. Then the child comes out, and parents want to sometimes interrogate the child about what was asked for. And it's just a situation that ultimately judges like to avoid. And I, as a practitioner, like to avoid it as much as possible too, and I think a lot of practitioners do, because it's just a bad situation for the child, and you have no control over what the child's going to say. You know, one child gets driven to court by one parent usually. You never know if there's going to be any kind of indoctrination or prepping. It's just very little benefit often comes from this, and there's a much greater risk of harm to both the child and your case. And I generally stay away from them. Another popular, very common aspect of custody evaluation is going to be best interest or risk evaluations. Best interest is very common. It will be utilized in most genuine custody issues, relocation issues. In New Jersey, the probation department usually conducts them. It's very simple. They come out, they interview you, both parents, they look at the housing situation, they get the history of the issues and each person's view of them, and then they write a report to the court. It does not usually carry any recommendation by the probation department. It's more of a factual analysis. Risk evaluation it's usually called risk assessment also, is to determine if one or any of the parents are or could be a risk of harm to the children. That's commonly utilized in a restraining order proceeding at the conclusion when you're investigating or determining what the parenting time schedule should be. They may want to do a risk evaluation on the defendant if there is an order entered to make sure that the children will be safe. A little less common are different types of appointments that the court can appoint individuals for children's representation. First is a guardian ad litem. This is like an attorney for children. Usually is an attorney, but doesn't necessarily have to be. It could be a social worker, psychologist. Not as common, partially because it's bringing a third person in to speak for the children, but not really do anything more than advocate. And when you're advocating, you're not really enlightening the court to anything more other than sharing the child's view, which is a very important role of the GAL, is to say what the child actually wants if the child's old enough to have a voice. But there's usually a cost associated to it. And, most people don't have enough for legal fees to begin with if it's in a custody dispute, and paying, a third professional is often very taxing. In addition, that's why they'll have custody experts. That's much more common. They can either be court appointed, they can be jointly agreed upon, or you can have your own individual. And you may have a combination of all of them. You can have the court appoint somebody, and then you both agree, or you both decide you want to get your own. You're always entitled to your own if there is a court-appointed expert first. Generally speaking, I usually recommend my clients seek a court-appointed custody expert first, because if the report is disfavorable, you have the right to get your own report. If you go and get an expert and that report's not favorable, you're married to that one, and you have to disclose it even if you don't want to rely on it. So it's just not the best first step to have your own expert. You definitely want to go the way of getting a joint expert. Then there's sometimes therapists and reunification therapy. This is usually not so much in a custody claim, but when there's a claim of interference or alienation and the court's trying to fix or remove or eliminate the problem that led the case to court, this is therapeutic for the children and the family. And then sometimes, very uncommon, is a shifting of attorneys and expert fees where appropriate, meaning if one parent is found to have caused a problem necessarily or alienated a child or interfered with parenting rights, they may shift the expenses incurred by the other party in the litigation to the parent who caused the problems. Not very common. I tell my clients, don't expect it, because if you are fortunate to get it, you're ahead of the game, but don't plan on it. It's not common. Even when they do award some fees, they don't usually make you whole. So it's just not something that you want to count on receiving. All right, so now let's look at these specific custody factors under this statute that we just talked about. First is parents' ability to agree, communicate, and cooperate. There's going to be a lot of similarities in the ones going forward because they mostly relate to the history of parenting issues, but there are subtle differences. So here is the ability to agree and communicate. That's with one another. We will often see that while both parents in a lot of high conflict custody cases treat their child or children like gold, they are incapable of communicating together for a child's best interest. They can't agree on anything whatsoever. Doctor's visits, appointments, calendars, payment of unreimbursed medical, everything is a battle. So it's a very important, and the first criteria the court looks at is to whether or not these parents can communicate, and that's probably the most important phrase in this first criteria, in the best interest of their children. Next is the parent's willingness to accept custody and any history of unwillingness, not based on abuse. This is an awkward paragraph because it's a willingness to accept custody. Usually both parents, if you're in a custody case, want custody and are willing to accept it. But this is really focusing on the other problems that the parents may have had with parenting schedules, enforcement of court orders, and things like that. Next is the interaction and relationship of the child with its parents and siblings. This is important because it doesn't necessarily mean siblings of the same mother and father in this case. There could be blended families and extended families that also are going to be considered now, as the definition of family changes to what the definition of this statutory factor is going to mean. Next is the history of domestic violence, if any. This is important. If there is a restraining order, that can carry or does carry the presumption that a parent getting the order should have sole custody, which we'll talk about later. Now, if the order does not say it, you can argue that it does not provide for it, even though the presumption is in favor of that. Because I found that most judges abhor a sole custody award, even when there's a finding of domestic violence, for reasons we'll get into later. And somewhat what we covered in the beginning is that they believe a child is best served by having both parents involved. So they do everything they can to avoid the presumption, even in a domestic violence case. More factors: safety of the child, from either parent from physical abuse or the safety of the child or other parent from physical abuse by the other parent. Again, it's a domestic violence factor, but not necessarily restraining order necessary. There could be violence in the home. There could be violence in the parents' pasts that make them capable or a potential violence in the future. The preference of the child when sufficient age, that's a hard number to determine. I generally say around 12, 13, they'll start to listen to a child. But in my experience, at no age do they let the child decide. I had a custody dispute of a 17-year-old who was going to college, and they wouldn't let the child decide because a child's not capable at 17, 18 of making sophisticated decisions like where they want to live and who they want to support them. And like I said before, courts don't want to put children in between their parents. It's not a good situation. It's a no-win situation for the child. So they avoid it at all costs. Next, the needs of the child. This could be countless issues, obviously physical, mental, emotional, educational, medical, extracurricular, any unique needs that the child may have, any unique skills or interests would all be relevant to a court. Quality and continuity of the the stability of the home environment offered. These are issues like, did the custodial parent move several times? Are they in a committed relationship with another person or not? Do they change relationships often? Just basically, how stable will the child be? How stable will the child's life be if and after the court makes this determination? Next is the quality and continuity of the child's education. In my experience, not the most important factor. Obviously, courts try not to move children like in the middle of school years. They try not to move a child, in his or her last year of high school. But of all the factors, courts will often say things like children are very resilient and can handle changes like this, that I find that they don't focus so much on that, but it obviously is a consideration. We continue because there are a ton of factors the court is supposed to look at. Again, in my opinion, they don't necessarily look at all these, although they're supposed to. And maybe they do, but they don't really say it out in the record. But it's important to know them. So fitness of the parents. This is obvious. Again, this is aside from the relationship and the history of parenting. This is just overall the parents. Do they keep stable employment? Are they dependable? Have they followed court orders? Do they have drug or alcohol issues? Things like that. Proximity of the parents' home, and that means between each other. So obviously, the closer that they are, the more of a changing parenting time schedule works, meaning going back to the presumption of equal parenting time and favoring equal involvement. If parents live 50 minutes from one another, it's an hour to pick up and an hour to drive back, you're not as likely to have as much shared parenting unless it's extended parenting, like 1 week with each. But you're not going to have a 3-day, 4-day alternating schedule when you live an hour apart. So it goes into factoring not necessarily who should get custody, but the type of custody arrangement, designation, and parenting schedules. The extent and quality of the time spent prior to the separation, meaning what was parenting like before. This is very relevant in a marriage that's now being dissolved. If there was equal involvement in parenting when the parents were together, it's stronger suggestion it should continue. But if there was more of a traditional setting where there was a stay-at-home parent who raised a child and another parent who was out working late nights and traveling, then it doesn't necessarily suggest or lead towards an equal parenting afterwards. Even with the presumption, I still find that if it was so unequal, like a traditional, then it's harder to get that equal parenting time, but still possible and still the presumption. So while that may be a little confusing, it means you have to work a little harder to show it's in the child's best interest when you want to share physical time after separation when you've had a traditional situation or set up beforehand. Employment responsibilities goes a little bit to what I was just talking about. If one or either parent has a very rigorous, long work schedule, travels quite often, unpredictable schedules or long schedules like police and firemen, this is going to be factored into what is the best custody and parenting time arrangement. The age and number of children, again, depending on the level of sophistication of a child, the needs of a child, factors to the overall evaluation of these issues, meaning an older child doesn't necessarily need a parent that's going to be at home as much. There's daycare and aftercare. But if you're an infant or a toddler, that's not necessarily the best situation, and the court's going to consider that. If there's many children, the court's preference is usually not to separate the children unless there's a compelling reason to do so. So these things need to be considered. It's the last factor, but it's equally as important. So let's talk about some of the legal terms. Now, generally, I tell clients, don't use these terms. Understand them, but don't use them, because often you're using them wrong. And if you ask for something with the wrong term, you can confuse the court to what you want. You could present an image or an issue that you don't intend to. And there's a lot of terms. There's really like 6 of them at least that we're going to talk about. I always tell clients, just tell them what you want. If you want a certain overnight schedule, if you want to be involved in certain decisions, just say that. The courts and the lawyers and all your experts will understand exactly what the term to apply to it is. You want to make sure that you're clear on what you're asking for. So the first important thing to learn and to understand is the difference of legal and physical custody. Legal custody is about decision making. Physical custody is about overnight parenting time. And that's really the basic of it. Now I'll go through a little bit of examples to give you so it's clear, but legal custody relates to major decisions. There are many, many things that are major decisions. The most common is going to be religion, like the choice of it, how to practice, medical treatments like surgery, not necessarily visits, education, not private school. Well, no, actually, I'm sorry. Private school is, and the continuity of it, changes in it. Now, this compared to day-to-day decisions, which would be like when and how the child does homework, what time the child goes to bed, and then there's sort of what I call depends decisions, meaning they're not necessarily major decisions, but they're also not minor decisions. One very common one is going to be extracurricular activities. Extracurricular activities are growing in significance to a child's life because of the world that we live in. The kids, at least in these areas, I'm in North New Jersey, this is 2018, kids aren't just running out, playing until the sun goes down and coming home. There's play dates, there's tournaments, there's traveling teams. Extracurricular activities are now much more significant to a child's development and education than they used to be. They're also significantly impactful to a parenting time schedule. So, you put a child into a weekly event that happens every Wednesday and you have a shared parenting arrangement, you're going to be affecting that child's parenting time with the other parent. Daycare is also another one that's kind of blended. Normally, daycare is viewed as the custodial parent's decision because they're the ones that he or she's the one that has to take the child every day. But, daycare is a lot about social development. It's also a lot about parenting time. And if you're sharing parenting time, then you have the other parent that has to cooperate. There's also significant payment that gets attributed to most daycare facilities. And when I say daycare, I mean, aftercare, pre-care, whatever the type of care is going to be, summer camp, things like that. Now, sole versus shared. One of the most compelling topics for people to talk about because there's always a great fear of sole custody. Let me first say that the presumption in New Jersey is for shared custody. As I said earlier, with regards to the restraining order, even when there is a suggestion that sole custody would be appropriate, courts shun it as much as they can. I've rarely seen sole custody granted, and usually it's when there's either something very egregious or an ongoing chronic history of either noncompliance, interference, or a complete inability to parent. So that being said, that you have an understanding that's usually not going to happen, let's talk about what it actually is. Sole custody means the sole ability to make important decisions. Now, even though you have the right to make decisions, the court rules and judges still require that you involve the other parent, that you seek the other parent's input, but you don't necessarily need their permission to be making major decisions like you would in a joint situation. Now, sole custody relates to Sole custody relates to decision making, not parenting time. So it doesn't mean that you have no overnights or even less than equal overnights. It just means you have less authority to make decisions. Now, generally speaking, if sole custody is being awarded, you're not likely to be sharing an equal parenting time. You're usually going to have a low or minimal amount of parenting time, just because it would be inconsistent with saying a parent who has sufficient or extended amount of time with the child can't make important decisions. So it's usually going to correspond to low parenting time or no parenting time, but it doesn't mean it. It doesn't mean that you can't have it. Now, that doesn't mean that shared parenting means equal parenting either. Shared parenting is sharing parenting time, but on a set schedule. If you had one overnight in the course of a year and the other parent had 364 overnights, you'd still have a shared parenting arrangement. And this is why I tell people to stay away from terms, because a lot of people talk about shared parenting when they want equal, or they'll say equal when they don't want equal, and then when they really want shared. But it's almost always going to be a shared parenting joint custody arrangement is what I want you to take from these parts at this point where we are. Now, when we talk about overnights, there's a definition of overnights, which is more important when it comes to child support, which we're not talking about in this webinar. I believe I have done a child support, and I'm sure I will in time to come. But the definition of overnights for child support purposes is at 12 hours or more. But this, I don't think, really means just 12 hours, because if you pick a child up at 8 a.m. and you drop the child off at 8 p.m., they're not likely counted as an overnight. The reason why I feel this way is I believe the intention is that you're taking care of the child overnight and providing meals and sleep and homework and parenting duties, responsibilities, and which is why you will receive a credit in child support for having the overnight, because you're absorbing the efforts and some of the costs. So, an 8 a.m. to 8 p.m. I don't think really is going to apply, although it would technically fit into the definition. All right, so let's talk about PPR and PAR. That's parent of primary residence, parent of alternate residence. This is often more commonly related to child support issues. There is a trend, in my opinion, away from the PPR designation. I think, one, it seems to be a very contentious issue unnecessarily between parents, and I think the courts are looking to get away from it, but also because it's more often only relevant for school enrollment, tax purposes like the dependent deductions, but it creates a lot of animosity, creates a lot of litigation, and it's really for a little benefit, and it generally doesn't impact the child necessarily. It's more of the issues to the parent, which goes back to what I said about best interests. It's not necessarily the child that's being served by these designations, it's the parent's interests. Now, one thing within this area, a case, it's called Wunsch-Defler, which you'll hear about. This is important in an equal parenting time arrangement. It's going to come up when parents are fighting over the PPR, PAR, because that's going to alter your child support calculations. I'm going to take a minute just to give you a snapshot of what child support covers and how the Wunsch-Defler case applies to it, so you understand it, because it creates a very complicated child support calculation. But the theory is important to understand. You're not likely to be doing the calculation yourself because it's complicated. A lot of judges even have trouble doing them, and lawyers alike. But so child support basically is set to cover the three main types of expenses that a parent incurs having a child: fixed, variable, and controlled. Now, your fixed costs are your costs that don't change, like your mortgage payments, your taxes, your health insurance. Your variable expenses are ones that do vary. Obviously, that's why they're called variable. Food, utilities, medical costs, prescriptions, things like that. Then there are controlled costs, which are the ones that you have a little more control over, hence the term controlled. These are like extracurricular activities and entertainment expenses. The Wunsch-Defler approach is for parents that have equal physical parenting time. The case recognizes that because you're sharing so much of the time, both parents are incurring a lot of the expenses that child support is normally being paid to cover. In a traditional setting where one parent is the parent of primary residence, has the more parenting time, has more of the expenses. So the Wunsch-Defler case created a way to adjust the number, I think by about 25% of one of the three types of expenses, to properly reflect the balance of expenses. Now, the interesting thing that I think about this case is I don't believe it was an appellate decision case, which means I don't think it's technically binding on the courts, but they all seem to use it. Now, and I could be mistaken about that. My last review of it suggested it wasn't, but I was surprised by that and haven't had a chance to go back and double check that. Either way, binding or not, courts use it, and you should be aware of it. Along those lines, things that you want to keep in mind. Again, some of this is going to be like a little bit of a summary and introduce a little more new terms into it. Best interest standard, can't say this enough, and it's because it's the most important thing. Every issue is decided on what's best for the child, even if they're not talking about the best interest standard, because some cases, some decisions require the court find the best interest standard being satisfied. But even when they're not, even when you're talking about things like child support or unreimbursed medical, the underlying theory is it going to be in the best interest of this child? So whenever you find yourself in a case involving any issue, keep this in mind. It's very important. It's something you want to present to the court, that is something you've considered and that the best interest is being served by your position. Next is change circumstances. This is significant because most agreements and court orders can't be changed without what's called a material and substantial change of circumstances. So just because your pay may go up 5% doesn't mean you get a review of child support. Just because the child's aged a few years doesn't mean it's time to review parenting time. Something substantial has had to have changed and that change has to go to the best interest of the child before a court's going to review anything. So if you're the proponent of a change or you're opposing a change, remember these two factors work together. It's got to be material and substantial change in circumstances that goes to the best interest, that either the change or the refusal to change goes to serving the best interest of the child. Never forget that that interest always has to be there. Presumption in favor of custody to victims of domestic violence, only for restraining orders. I don't know what they mean by not restraining. I think that's a typo. Because the presumption is both. But you need to remember that I often counsel clients to do what they can to avoid even going to defend on a restraining order, because it does carry this presumption. It can greatly affect your custody rights now and for a very long time. Another thing to know, if we didn't talk about it because it's kind of being eroded now, is something called the tender years doctrine, which for many, many years, and I still think it's technically valid case law, said that a child's best interest is served by being with his or her mother. So a child of tender years would go to the mother for custody, and that's why I speak of traditional parenting arrangements. That is being eliminated. And there used to be, arguments made like, the parents breastfeeding, the child can't be away for that long, and things, it's frozen, there's pumps. So, what used to be traditional reasons for parenting has just now kind of fallen by the wayside with, the changes in presumption and the types of blended families that we now see. Parenting time is the term. It's not visitation. This was changed many years ago with the recognition that the non-custodial parent, going back to the PPR designations, is no less of a parent. They're not visiting when they have for the weekend. They're parenting. So not only is it a change in the mindset and the perception, it's also a change in the authority and the role that the parent is playing. So when you have your parenting time, if this is your weekend or your holiday or your week, you're making the day-to-day decisions. You're in charge of the emergency decisions. It's your time to parent. You're also responsible for clothing and doing laundry and doing homework. So you're the parent on both sides, not just the benefits of making decisions and having control. It's also the obligations and responsibilities. Parental alienation I bring up because it's a very popular term. It's a buzzword all over the internet. In my opinion, it's a little overused because parental alienation takes a very long time. I've often said that you can't really have true alienation unless you have cooperation from both parents, meaning the parent who has been alienated did very little to prevent it over a course of a very long time. Now, this is not to say that it can't happen quickly, and it's not to blame necessarily the non-custodial parent or the absent parent. But if you're a parent who's aggressive, you're constantly enforcing your parenting, you're constantly enjoying your parenting time, you're constantly communicating, whether by FaceTime or sending birthday cards, you're constantly going to court when the parenting time is missed, you're not likely to be alienated from this child's life. If you think it's easier to sit back or stay back because mom, again, I use the term just for ease of communication. If mom's denying you a lot of parenting time and you sit back thinking, well, the child will get older and I'll get in then, or, I don't want to keep going to court because I'm taking off work, all these excuses, which are legitimate, but are your acquiescence to the situation. If you are aggressive and you stay on top of your rights, you're not going to be alienated. Another thing to look at, case of black versus black, I throw it underneath this because it's a case about college contribution, but college contribution is very important. One of the factors based upon is the relationship of the child and the parent that they're seeking contribution from. Black versus black just talks about something called the Rutgers rule, which is a position a lot of people take that they should only have to pay up to what would be the tuition for an in-state school, even if the child's chosen to go to an out-of-state expensive school. It's a very persuasive argument, and in certain circumstances it's applicable because of the financial situations, but it's not a binding rule or position on the courts. It's really, again, going to be the best interest of the child, capability of the parents. More things to keep in mind. Determinations will not be based on these things, mostly financial decisions. Custody will not turn on financial decisions. It does not matter who makes more money. It doesn't matter who's going to give nicer things or a bigger room, and it certainly doesn't matter who's got a nicer house. Something called like a three-pony rule, meaning there's only so much a child needs in the first place. Now, don't get me wrong, it's obviously significant to a court the lifestyle the child is going to have, but they're never going to deny a parent equal parenting time because there's one less bedroom or because there's a discrepancy in income. There are also alternatives when you do have a great distance. And I don't mean, 30 minutes or even 60 minutes, in a different county. I mean different states, different countries. Normally you will have extended vacation time. You will have, like when it comes to school vacations, usually there's 3, maybe 4 to a school. You'll sometimes have 2 or 3 of them so that you're making up for the lost time. You'll often have greater time in the summer where normally you'll have like 2 weeks of uninterrupted parenting time. You might have 4 or 8 weeks as an accommodation if you're not going to have your constant parenting time during the year. Courts acknowledge and look to changes in technology that allow more contact, FaceTime, email, things like that, as a way of keeping a child in contact with a parent who's going to have more absence. And one last thing to keep in mind before we move into the relocation is, 2 things to keep in mind. One is I generally recommend people avoid the police station for pickup and drop off. It's common when there's either a restraining order or high conflict between the parents. But a police station can be sometimes somewhat traumatic to a child. They start to question, why am I not safe am I going to a police station to have to see my father, my mother? It raises questions to the child that can also be traumatic. The belief that people use when they choose this is that they're safe there, and that's also why the issue is being picked up by children. I usually recommend a firehouse. I think, children often like firehouses. They're the heroes. They get to look at the truck and things like that. But there's also a sort of authority that comes along with that role and the uniforms and the job. So I think you get some of the control that you perceive a police station has in a fire station. So I just think it's usually a better option, so I put it here. And then my last tip, which is truly the last thing to remember, is about the Hague Convention. The Hague Convention is the international law that governs custody issues around kidnapping or relocation. If a parent leaves the country without proper permission, there's a convention pact between many countries to work together to have this child returned. I say understand it because not all countries subscribe to the Hague Convention. So you need to know when there's a relocation issue or a kidnapping issue. But I shouldn't say kidnapping. It's actually an interference issue, parental interference issue. You need to know whether or not the Hague Convention applies. One, because there are rigid time frames that are required for filing to preserve your rights under the Hague Convention. You also want to get attorneys who are fluent in these types of applications for international custody. So if you think this is an issue or ever will be an issue, it's good just to get familiar with the convention now so that you're not running to catch up when you have a real problem. So now let's talk to you about relocation. Relocation is probably one of the most difficult issues that parents go through with regard to custody. It's probably one of the most difficult for judges to have to decide. It's just never a good situation if you're separating a family. Win or lose, that's going to impact the child. Meaning, if you have a parent who wants to relocate and the other parent can't, you're taking the child away from one parent in the way that he or she knew and related to them before. That's going to be impactful. If you prevent a parent from relocating, that parent's going to have bad feelings. Their life is going to be harmed in some way. The benefit that they were going to get by relocating has been lost. That's going to impact the child. So you really can't win in a situation like in the average situation of relocation. But what I want to talk about is a recent case that actually two cases, but a recent one that has, in many people's opinion, greatly affected relocation standards. And that's Bisping versus Bisping. This is now an appellate decision, which means it is binding on trial courts. I say that because I represented the father, Glenn Bisping, at the trial court level. Now, what's important about Bisping is the agreement that they had and the time frame. The agreement that they had for parenting, and I don't remember the exact facts now, it's been many years, but they had an agreement that recognized that both parents needed to be involved in their children's lives, that physically separating them by a certain distance would be harmful and impactful to the children. They did share equal parenting responsibilities. And when I say that, actually, equal parenting responsibilities doesn't necessarily mean equal parenting time, but usually equal parenting time does mean responsibilities. But you could have less than equal parenting time, but be just equally involved. You could be the one who goes to all the events and takes the child to all the events. You're bringing the child to doctors and you're going to school conferences, and but you may not have, 7 days out of every 2 weeks, but you're equally involved. So they had an equal involvement, but not necessarily an equal schedule, I believe. The mother also was seeking to relocate about a year after the settlement agreement was entered. That's significant because there's a presumption under the case law that says if you seek to relocate within a year of your custody arrangement or your divorce settlement, it's deemed that you're acting in bad faith when you entered the agreement because you probably knew you were moving and you withheld it so that you could get a more favorable parenting schedule and an easier attempt to relocate later. And that's exactly what we argued. So we were arguing that the agreement prohibited relocation because the parents agreed in the best interest of their child that they shouldn't be physically removed from one another, and it was being done within the year of the agreement, and it's bad faith. Court denied that entirely and granted the relocation, which was probably one of the worst decisions I've ever seen by a trial court on many levels. And I'm not saying this because I represented Dad. I'm saying it because it truly was a horrible decision. The appellate court agreed and reversed it, fortunately. Now, the impact of this case is with the best interest analysis, in my opinion. A lot of people are reading this case to say that, well, let me go first to talk about the Bowers versus Lewis, which is the case that defines the standard to utilize for relocation, is believed by recent decisions to be a flawed social science that whatever was good for the parent inures to the benefit of the child. So traditionally, if you had a relocation, and again, I'm going to say mom is saying, I'm going to move because I'm going to make more money, I'm going to have a lower cost of living, I'm going to have family support. Judges almost routinely say, well, that's in the child's best interest. You know, a happy mom is a happy child, and will grant relocation. Now they're starting to realize, and I think Biz being open the door for this, that that's not necessarily the case, that the issue has to be the best interest of the child. So just because mom's going to make more money doesn't mean that that's necessarily better for the child. It suggests that it is, but that's got to be weighed against the loss of the relationship the child's going to have with his or her father. So it's not just a bright line, yeah, mom's going to be benefited, let her go. So the reason why I think Bisbing did not make such a huge impact as people want to believe, and even some judges want to believe, is because the facts of the settlement agreement were so compelling against the relocation that it didn't matter what the standard of Barrow versus Lewis or even the best interest was. The parents had agreed that it's against the child's best interest, and the parents still have the right to decide what's best for the children. Courts only get involved when parents can agree. So if parents have previously agreed this is what's best for the child, it's not for the courts to overturn it. So, but what I do recommend people take from Bisbing is to use these types of agreements in a custody or divorce settlement, meaning it's in the children's best interest or child's best interest that they stay close in proximity to both parents, that we are sharing equal parenting responsibilities, even though our parenting time schedule is not the same. These are things that are going to be very clear points for the courts to consider when determining whether or not it's in the best interest of the child to relocate. All right, so I believe that's it. So I'm going to take a second, see if there's any questions. Like I said, I'll stay as long as necessary to answer any that you may have. I may pause the recording for a second, so that while I wait to see if anybody is going to pose a question, those that are watching this later don't have to wait for that. Oh, and as I said, I think I said in the beginning, this will be posted on my website and on my YouTube page, so you can obviously watch and download it. You can't obviously get your questions answered, but you can always call us at 973-562-0100 to set up a consultation. We have a new feature now also on your cell phone. If you text the letters MLG, which is short for Micklin Law Group, to 72,000, you'll be subscribed to free downloads and information. Obviously, it's all confidential. We're not going to do anything with your information or sell it. It's just an attempt for you to be able to get information from us, like these webinars that we're creating for people, quickly and easily to your cell phone. So I'm not seeing any questions, which hopefully is good. Hopefully it means I've covered everything that is of interest to you. So with that, I'm going to wish you good night. Thank you for coming. You can go to our website. I don't know if the next date is up yet or not. I'm sorry, I didn't get to check it beforehand. If it's not, it will be up shortly. And then you should also receive emails or whatever notice that brought you to this tonight. You should receive similarly in the future. And you can always call my office and get any more information. Thank you. Good night.